All right, we're going to go back to our earlier story, of course, the Meyiwa case restarting, and we'll be talking about that with, of course, our legal analyst, Nthabiseng Dubazana, in a short while. The Senzo Meyiwa murder trial, indeed having a new judge at the helm. This is the case starts afresh from tomorrow, with the witness expected to take the stand. Of course, Griselda Lewis has been presenting that for us and watching that case quite closely for us. 5 men, of course, currently on trial for that 2014 murder of the soccer star. Let's then speak to Nthabiseng Dubazana, our legal analyst, to weigh in on this. A very good evening to you, Nthabiseng. It's always a pleasure to see you. Thanks for being with us.
Thank you so much for having me.
You're most welcome. All right, let's talk about what the process is, when it comes to, a trial restarting. I mean, are the issues that we have now sort of established as being a common cause and we don't have to go over them again? Or it's literally a case of we are starting from scratch?
It is literally a case of starting from scratch. That's why today we heard the presiding officer and the parties that be preparing for a pre-trial conference. So the purpose of a pre-trial conference is to deal with exactly that, to deal with issues that are in dispute and those that are common cause. So we don't need to deal with them in the actual trial. We only focus on those that are in dispute.
Yeah.
The hope was that this would have been done before today, if indeed the presiding officer's name was known to the parties before today, and then today would have been a way forward in terms of starting the trial and the accused persons pleading guilty. So what we saw today is that the trial really has not started because the accused persons haven't pled as yet to the charges or the indictment, like the new one that has been amended today. So we'll see tomorrow, once the pre-trial has been dealt with and then the attorneys and the presiding officer agree that the matter can now start, then the trial will officially start once the charge is put to the accused and then they plead to that charge.
Are we going to pretend that, what was said in the previous trial wasn't said? And, the reason I say this is, are we sitting in a situation where if there is a clear contradiction, made, by one of the witnesses on the stand, are we then able to, or the legal representatives of the opposing side, able to say, hey, look, this is what you said the last time, and this is what you're saying now? You mentioned that this is literally a case of starting from scratch, but surely where there are some sort of contradictions and big contradictions as that, would that be cause for concern or cause for something to be raised there?
Absolutely nothing. So at this stage, you must just accept that whatever was dealt with in the previous case, that's where it ends, that's where it stops. We're starting fresh with this new presiding officer. In fact, he was very clear to read one case today, wherein the parties in that case had agreed that certain aspects of the previous matter, which had to start de novo, were to be used in the new case. But then Ndate Baloi for the state read out the directive that emphasized that this is a case starting from de novo. Nothing from the previous case will be admitted within this case. So everything that we know from the previous case, scrap it in its entirety, and you're going to start as if nothing has ever happened.
Yeah, I heard that the new judge wants to get the new trial underway quite quickly, and that kind of raised a red flag for me. And that, does that mean we're going to be, if we're doing something quickly and speedily, does that mean that, we would kind of overlook certain things and we'd rush through the process? I mean, as we know, this trial has been going on for some time. One would expect that the second trial or the new trial would also take just as long. Should there be concern about the new judge perhaps overseeing certain things, given the fact that, he'd want to move on from this trial quite quickly, as was mentioned?
Well, given the way he dealt with the matter today, he definitely left no stone unturned. He ensured that the accused persons understand the charge that is leveled against them. He wanted to find out if they were served with it. He ensured that the Section 35 right is reread to them so they understand that they make an application for legal representatives, albeit they were already there in court, but he has to verbally say it. And then he also wanted them to know that they still have the right to apply for bail because this is a new matter.
Yeah.
But then, of course, he can't hear the bail application, have to be heard by somebody else. But judging the way that he started this matter today, I don't think it's going to be a rushed job. What I think is that he's going to avoid the numerous applications that were happening in the previous one.
Yeah.
And that was caused mainly because disclosure wasn't done properly. Remember, in the middle of the state's case, the second docket came into light, and that was never disclosed to Advocate Mushololo, for example.
Yeah.
And then it became a whole other application within an application. So I think that's what he's trying to avoid in ensuring that the matter goes, full force into the actual merits of the matter.
And let's not forget about that fact, that there is this second docket and possibly other people that should be accused in a sense. Will this new judge bear in mind that there is this particular situation, and perhaps we see that being dealt with quite differently to how it was dealt with? As you mentioned, Advocate Mshololo not being aware the previous time, but now I would say that this is something that is common cause at this time. So does that then bear fruit? Does it mean that something will happen based on this particular second docket?
Yes, so at this stage, it can be assumed fully that the defense attorneys have the entire state docket. So the purpose of the pretrial is to ensure that that is actually the case, that no attorney is missing a certain part of the docket, that no part of the docket is yet to be discovered, that there's no further investigations that are left out.
Yeah.
And then, as a result, we're going to deal with, for example, statements of witnesses who have died since the trial started.
Yeah.
They need to decide, the state rather would have to make an application whether or not to hand in those statements as hearsay evidence, and then they be accepted provisionally by the presiding officer, I beg your pardon. And then towards the end of the state's case, then the presiding officer can then decide whether to admit that hearsay evidence based on the application of the state. So these are the things we're going to hear about tomorrow. What is in dispute? What is not in dispute? Are there going to be 220 admissions? Are they going to not be 220 admissions? Stuff like that. So that's the whole, they're going to narrow the issue so much that the trial can actually really commence, and we hear more than we heard in the previous time.
I'm thinking about how, this might actually work for some of the people, who were witnesses before that this trial is starting again. I'm thinking of a particular hostile witness whose name I shan't mention in case I get into trouble myself. But, this could possibly work for some of those hostile witnesses who might be thinking maybe this is an opportunity for me to present myself, differently to the court. And you're saying that, we can't really reflect on what was said before and what was done before. So this might actually work for some of the people that were perhaps rather hostile as witnesses in the previous trial.
100%. So this is just a new way for them to, like you said, to present themselves to the court and the evidence that they're coming with, and then hoping for the best that as the cross-examination continues, because now we don't know even the sequence of how the witnesses are going to be called anymore. We don't know how the questions are going to be phrased. Like Memshololo said today, we should not take for granted that the state will follow exactly to the T what had happened in the previous trial. So we have to expect the unexpected and see how best the state is intending to use its witnesses going forward, and how the defense attorneys are going to structure their cross-examination. Probably they would have learned a thing or two from the previous trial and decide to, kind of throw in curveballs here and there based on what they learned in the first trial.
All right. It's always great having you with us. We certainly do appreciate your well-thought legal analysis. Nthabiseng Dubazana, legal analyst, they're weighing in for us, of course, on the Senzo Meyiwa trial. The murder trial has a new judge at the helm, and, of course, the trial set to start afresh from tomorrow, with witnesses expected to then take to the stand.